were sought in relation to the application, and thereafter I will make a summary and a way forward.
Thank you, Chair. Let me start with Honorable Gonde while it's still fresh, because I think has a quite easy issues to just get out of the way. Now, Honorable Gonde, just a bit of background. The list that we submitted to the chair, can't remember now when. We were given some deadline to provide a list of witnesses, and we provided it under the heading, the chair, if you remember, the chair announced here the day after we had provided that list. And he specifically called it a provisional witness list. And that was because that was the heading of the list that we gave him. And so that covers your first question, the explanation of why we called it a provisional list. Well, let me put it this way. The reason we called it a provisional list is because it is a mixture of all the witnesses that we intend to call. And so that would involve witnesses that we've consulted with and those that we have not consulted with, or those that we might have wanted to be subpoenaed, for example, because either they are not willing to come voluntarily. That's how a witness list gets compiled. When we got the list from the evidence leaders, it was the same. It was a list of all sorts of people. Some of them were called, others were not called, others were subpoenaed, others came voluntarily, and so on. So that's an answer to the first one, whether we've consulted with all the witnesses. The answer is that with some of them, but obviously not the unwilling ones, or those that we had not been able to reach at that stage. Yeah. But that's not even the problem, Honorable Gonde. The problem is not whether we've consulted or not consulted. It is the point we're really making is that the DA put in its papers that list, and that comes to your second question: why is it confidential? It was wrong for the DA to do that, because that list is by its nature confidential. I explained it to you why the evidence leaders made a point of informing us that their list was confidential. And that's why we made sure it doesn't even reach. It could have been very juicy news if you saw some of the names there, but we honored that arrangement because it can drive witnesses away or just invade people's privacy unnecessarily, who may not even ever be called as witnesses. So that's why it's confidential. And as I've said, it has already happened to us. Some of the witnesses are already reticent, exactly because their names have been bandied about, where we had provided them with a guarantee of confidentiality. You are obviously right that ultimately, if those people come to testify here, they're not going to testify in camera. They'll be sitting there. But that's a different issue. Once they're here, then obviously it would have meant that they have waived whatever confidentiality. But it's not fair for me to say in my list of Honorable Gonde, and it might turn out that you might want to change your mind, or you might never even be called. But you'll always be identified as that person who was once prepared to testify. Anyway. So that's why it's confidential. Then there was the issue of witness statements. No, the witness statements are not of our witnesses. The witness statements that were attached by the DA were the witness statements of the people that I mentioned. Ms. Mokhaladi, Munsisi, Tejane, I can't remember the other one. And our objection there was simply that to put those statements in court papers is disingenuous. I mean, there's no other word for it. Because you put, let me give you an example. You'll put a statement, who was it? Baloyi, I'm not even sure, Ms. Baloyi, if her statement was there, but I'm just using it as an example. You remember one of the things we've been joking about it here was that she said the public protector wanted to be called madam or to be bowed down to. When a question was put to her, it was clear that is just an imagination on imagined kind of situation. So if you want to put that statement, then you have also to put that statement was since retracted, if it was retracted or qualified or whatever. You can't just put it in court papers before judges who don't know that this person actually retracted the statement or it was discredited by other witnesses. So that was the point we're making this. Okay. So it's wrong for the DA. Anyway, while I'm there, I might as well deal with one of the issues of Honorable Maneli, because it's related to that, as to why there were a reference to political parties. There is a reference to political parties because political parties are represented in this committee, as it was explained. I mean, we all know that people, unless we're not naive to think that people are just here, representing their jackets. They are here representing their political parties by design. Of course, honorable members have taken an oath of office to act as according to their conscience and so on. That principle was established in the case of the UDM, the National Speaker, so-called secret ballot case. But you can't run away from the fact that people are here representing parties. That's why there's proportional representation. There's so many for the ANC, so many for the DA, so many for the AFF, so many for whatever party. It's political parties. It's not a secret. It's not some secret that we must whisper about. It's a fact. So that's really the context in which it was raised. And then while we are with Honorable Maneli, whether it was a general point, okay, I've dealt with that. And dividing the committee, well, I have no interest in dividing the committee. But it's true that the people are here representing political parties, or whether they come with mandates or not is not for me to say. But they represent their political parties. Holding a brief? No, I don't hold a brief for any political party or political parties. I speak to all members of political parties here, even here. Again, that's not a secret. I speak to them here in front of everyone. Some of them I've known for half of my life. Others I have, relationships that go beyond this. Some of them are even my clients. So I don't hold a brief for them in this particular. I might hold brief for them in other court proceedings, like I do for General Olomisa, for example. So I'm not going to stop talking to him about other matters that I'm involved in with him just because there's this committee. And the point I was making there was not holding a brief or whatever. It was that the members the point that was raised was not so much the absence of members or the issue of a quorum. It was that there had been, and that's why I was raising with the chair, there had been a specific communication with the chair to the fact that there would be no sitting this week, and therefore some people were comfortable to go elsewhere. They might have chosen to stay here, maybe. I don't know. But we've already said that's a matter for the chair. Even when I raised it, I had said that I don't want to enter that space. But I don't want also to participate in a meeting that is not properly constituted, if it is not. If it is, it is. That's fine. But it's my duty as a professional to raise it with the chair. If there was, let's assume there was no quorum, for example, I would have said to the chair, have you noticed that there's no quorum? Otherwise, we'll all be sitting here wasting our time. Okay. The fairness, No, Honorable Maneli, what I was saying about the fairness of whether the public protector's view of the merits of the case, I was saying it in the following context. I was saying she does not believe, and neither do I, nor would any reasonable person believe that there's been anything that has been said here that constitutes an impeachable offense. So the point I was making is that if you wait, it's that dilemma that was referred to by Justice Ngob. So if you wait until the outcome, then you can run a process which might take months. Let's say it's a trial, months and months, and then at the end you ask for a recusal. That's one way of doing it. But that way is not recommended because it would mean that you're just wasting time when waiting for the outcome. So that's the first thing. The second thing is that if you do that, you can also be accused, rightly or wrongly, that you are only doing it because the shoe is pinching, because you don't like the outcome of guilty or not guilty or whatever. And then suddenly you find all sorts of retrospective reasons why there should have been a recusal. So that's why the Constitutional Court says you must raise it as soon as it is up, as soon as you have the reason. I think the court said where the litigant has knowledge of all the facts upon which a recusal is sought, it is not in the interest of justice to wait until an adverse judgment before raising the issue of recusal. So that's obvious. So I was saying in this case, we don't even have to wait for a so-called adverse outcome, because if there's any justice, there'll be no adverse outcome. So, but we're still raising it now. And it was also in the context of turning this into the CCMA and having all sorts of witnesses who don't speak to the issues. But that's a debate for another day. Okay. Honorable Ngola, I agree with you 100%. It's not the first time that this is happening. That where there's a matter that's going to be raised in this committee, it should not play itself in the public domain. It's the same issue, the same complaint. You should at least accept that I agree with you, because that's the same complaint that we're leveling against the DA of putting in the public domain documents which are, strictly speaking, only before this committee. We don't know why they did that, but we have no control over. We have no control over what members do with their own documents. If members decide to give documents on Twitter, or whoever they want to give it to, we have no control over that. I suspect even the chair doesn't have control of what members do with the documents, which they get given legitimately, but might use for illegitimate purposes. It's just people's discipline that we can rely on. We can't say the chair must not give people documents, but we assume that everyone understands the protocols and so on. So it's regrettable that anybody the only thing we did was to send the application to the chair, and I'm assuming the chair sent it to the members. What the members did with it is not our business, but I agree with you. The next issue is okay. This issue of the 2 weeks. Look, I don't know why this is misunderstood. The reason why I've been at pains to find words to even describe it is exactly what you're saying. There was no agreement in the true sense of the word. It was an understanding between us and the evidence leaders and the chair. If it was an agreement, I would tell you. So I don't want to accuse people of things that are not there. It was not an agreement. It was an understanding. And Advocate Bauer is right. Even that understanding was not rigid or cast in stone on the 12 tables. It was a moving target. If the evidence led us in a particular way, that 2 weeks would also move. It's not like it was from this particular date to that date. But what I was just explaining why there was that understanding, why we even made that request, whether it was accepted or not. And I've explained, I don't want to go into that as well, why we needed that period. Advocate Power is right. It's not a criticism of the evidence leaders, or I'm not saying that they had 100 months or whatever. I don't care whether they had a month or 2 months or whatever. I'm just saying anybody who's preparing to lead witnesses requires a period. Whether it's 1 day or 2 hours or 2 minutes is irrelevant. It requires a period where you check the evidence of the other side, cross out certain witnesses that you might have thought you need and don't need, resequence your witnesses, reconsult if you need to reconsult on certain issues that might have arisen. For example, now we have 2 witnesses. 1 or 2 of those witnesses might say something that might either lead me to eliminate witnesses or to add witnesses, for example. I've said that the chair will tell you, I can't remember which witness it was, where I said, I'm going to give you these propositions. If you agree on these propositions, it might eliminate my cross-examination or even witnesses to call. Because why would I call someone if the evidence has been considered, for example? So it's that kind of management process. It happens in every situation, where, particularly of this magnitude, where there's so many witnesses. If it's a big criminal trial, there'll be a kind of short break between the evidence of the prosecution with 100 witnesses and starting the other witnesses. Yeah. Okay, but anyway, that's why we wanted the period, and I was just saying it's unfair the way it had panned out. Yeah. Has there been a conclusive list of witnesses? That is Honorable Mola. I've already answered that question when I was addressing Honorable Gonda's issues. The reasonableness of the time of the 2-week thing, again, there's no, I don't know what the reasonableness is. In my view, 2 weeks is reasonable. Maybe I need 3 weeks, maybe I need less or whatever. It's not written in any book. Yeah, it just depends on each particular process. So reasonableness can be judged by others. And this is the perspective that needs to be put there. The evidence leaders, when we had meetings with them, had informed us that they will finish, their last witness would be on the 26th of August. That did not happen. It's not their fault. The evidence just took us in that particular direction. Then they told us that they would finish on the 10th on Saturday, the 10th of September. That's the Saturday where we sat here. Also, that did not materialize because, as I say, you can't control these things. And that's why I was saying the 2-week thing was a moving target. Yeah. All we're asking is the same understanding from our side, that if things don't work out in the way that we might have predicted, there should be flexibility. So we can't say now the 26th August became the 10th of September and it became something else, but the date on which we have to start remains the same. I mean, that's just blatant unfairness. Because as that date moves, it then shrinks the period, the so-called break period. Yeah. And Honorable Ngola, I'm sure it was a slip of the tongue, was referring us to a backdoor process with the chair. We don't want a backdoor process with the chair. It's the back room. Yeah, we can go.
Yes, back room.
Okay. Thank you, Honorable Ngola. And Advocate Bao and I will not participate in a backdoor process with the chairperson or anybody. Okay. So, all right. Now, on coming the last, I think that covers those. The last, no, there were 2. Honorable, I think is it Van Minen? Yes. And you asked about the application, yes. No, the application for postponement was not because the legal representatives were tired. We wouldn't have known on Sunday already that we're going to be tired on Tuesday. We started on Sunday. I think I traced it on the day, but basically the timeline was this, honorable member. You'll remember that on Saturday we had Mr. Jane. We finished around about 6 p.m. When we finished, I said, I want to raise something for the record for the chair. And I said, we have just now been involved in this urgent application because the DA had served us papers the previous night. Unfortunately, I couldn't even, the reason I didn't sleep that night is because I had to deal with the DA application, which arrived around about 8 p.m. and prepare for the cross-examination on Saturday. So that's what I did. So when we finished the evidence of Mr. Jane, I then raised it because I didn't want members to be brought here the following Tuesday in vain. And I said, there's this possibility, but because it's late in the day, we'll deal with it in the back room, not the back door. So on Sunday, I then initiated the backroom process by sending a WhatsApp to evidence leaders. And I said, it was even before the president, I think, came into the picture. I said, look, it looks like we're going to be involved in this thing. No, it must have been after, because the president had already said that they wanted more time or whatever. Then the feedback I got from the evidence leaders, I can't remember now, was that no, that was not acceptable to the chair. So that's why we then wrote a letter on the 12th, which was the Monday, to the chair to say, please, now we're formalizing the thing outside of the back room. Please, these are the developments. The chair wrote us back and said no. And that's why we sat on Tuesday, which is what we had been trying to avoid from Saturday. So when we sat on Tuesday, because we had no choice, we had to come here. We then said, this is the situation. We are now, everything that you must have heard, inundated. There are now almost 2 or 3 other parties more than Saturday. And on top of it, the public protector is not feeling well, which obviously, again, we wouldn't have known before that morning. And the rest, you know what happened there. So the thing about the 9 o'clock deadline was just something when the chair then asked me the minute details, now, what are you actually going to do? It was raised in that context. So I was illustrating to him that actually, even now, as 9 o'clock, when I came here, I had just met a deadline. So I would not have been able to prepare for the cross-examination of Mr. Jane, for example. So it was only in that context. But that was not the reason why we asked for the postponement. List of witnesses. No, I think that was your only issue. Am I right? Thanks. So sorry, missed my note here. No, I was mixing your issues with Honorable Manani's. Chairperson, I really take strong exception to what Honorable Manani's has done, because, and I want to thank the Honorable Member who tried diplomatically to call her to order, to say we are now here, we're not in the deliberations. In your deliberations, you can insult me as much as you like, but it's not correct to use this platform now of clarity to say the things that are false and not true, and secondly, which will clearly have to be responded to by me. I don't want to enter that space. In actual fact, I know the member withdrew, and I accept that. But for her to have said that she was of the view that I abused them, whatever, and saying that I have insulted anyone, I've never insulted anybody here, never, not once. Otherwise, you must tell me who I insulted and what the insult was. Yeah. So instead of complaining about abuse, she was actually abusing me. and I don't take kindly to being abused, as you know. So, but I accept the withdrawal of those statements. But insofar as the honourable member saying that we should do the right thing, I agree with her. I'm just simply saying the back room, it was not just myself and Advocate Bauer. It was myself and Advocate Bauer and the chairperson. So he must do the right thing as well. And at the moment, the right thing is the recusal application. So and I accept again the criticism that you give to us, at least my part of that criticism, where you're saying that it means the backroom failed. Obviously, if things were managed properly in the backroom, as I've explained now to the honourable member. For example, the sitting last Tuesday should not have happened at all if the backroom had happened the way it should have happened. We should not have sat here. There should not have been so-called threats or doctors' notes and all that. It should not have happened. I tried from Saturday to prevent that sitting from happening. Everybody who's honest knows that. I tried on Saturday, I tried on Sunday, I tried on Monday, I tried on Tuesday morning, as I've explained here, to say we should not even come here to sit. Even before I knew that the public protector was not well. Even worse, then the public protector fell ill. So if you want to blame me for that, I'll take the blame. But, you know, I can't, unless if you wanted me to put guns on people's heads, then which I'm not inclined to do. So that's really what we tried to do. The public protector tried everything in her power to prevent this. But of course, we were blamed. We were the ones who should be lynched and burnt at stake. That's fine. Then the issue. Okay, I think we will help the chair about that later. It's closer to you noba uya ngapha uzobulawa noba uya ngapha uzobulawa, between a rock and a hard place in English. Yeah. But you B7. Oh yes, Honorable Mangani, he said you wanted the list of the witnesses who are not relevant. Yeah. Okay, we'll supply you that list. I don't know it offhand, but let me just give you an answer that might tease your mind there. I think it started with the witness Shunji, where before he testified, I made a presentation in the morning to say this witness is irrelevant for this and that reason. The chairperson made a ruling to say, I've already said, well, we'll deal with it when we deliberate, which is wrong. Well, there's nothing we could do. Again, we can't stop the chairperson from listening. Even when I was cross-examining that witness, I said, well, since we are here, I have to ask you some questions. That happened with the next witness. I can't remember now the proper sequence. I made the same objection. The chairperson overruled it. It happened again with the third witness. I made the same objection. The chairperson overruled it. Now, I might be many things, but I'm not mad. So I can't keep on saying the same thing for every witness. So after 3 witnesses, I gave up. So all the other witnesses were irrelevant. There was nothing, because I knew what the outcome. I even told the chair, I know what the outcome is going to be, but I have to do it to discharge my duty. So there were countless other witnesses who came with irrelevant evidence, but there's nothing we could do. We can't. I've said that it's closer to impambane bonakala ngoba uphinde wenze the same thing so many times, or uthathe i-emery yokhamanzi kodwa uyayibona ukuba iyavuza. I think it was Einstein who said that madness is repeating the same thing that has failed. I'm not mad. So we'll give you those witnesses, but I can tell you this much. There were 18 witnesses that were caused by the or that will have been called by the evidence leaders at the end of this. Only 3 of them, well, if you don't count the so-called expert, the 2 others, Mr. Van Lochenbeck and Mr. Pillay, those are the only witnesses who were called here that were not employees of the Public Protector's Office. So the 15 witnesses are employees of the Public Protector's Office who are telling us about all their problems about this meeting and that meeting and what have you. That's why I said this is being turned to the CCMA and or the labor desk of the Public Protector's Office. Maybe that's what this committee was supposed to be. But I would have thought those things can go to the National Assembly, not to this committee. But that's a story for another day. So of those 15, I think maybe half of them fall under that category. But we'll give you the list. We're totally irrelevant, completely. Yeah. Chair, I think that covers everything. Thank you, Chair. Sorry. Oh, I'm sorry, my Chair. The issues raised by the evidence leaders, I would have wanted to respond to them before the members actually spoke, but let me just quickly deal with, don't know where I've made that note. Okay, I'll do it offhand. I have, I've already explained that when I say the evidence leaders did this or did that, it's not necessarily a criticism of what they did. There are areas which may be properly construed as criticism. The recusal application is not aimed at the evidence leaders. The recusal application is aimed at the chair. So if the chair did something together with the evidence leaders, well, it's the chairperson's share of that conduct which we are interested in for now. So I think that's the spirit in which it should be addressed. And I don't know about the dictionary meaning or here's my note of collusion, but that's the spirit in which we meant it. That there were meetings which we regard as untoward, in the sense that I've explained the sense. As this is mercifully not my first commission or process of this kind as well. So I know that evidence leaders and the chairperson have a different type of relationship, but that's why I qualified it. Was hoping to avoid this, to say that if there's a matter that is raised by us or that concerns the public protector, that matter we expect it to be debated with both sides, quote unquote. That's what happens in every commission that I've ever participated in. But it doesn't mean that every time the chairperson has to speak to the evidence leaders about this, that, or the other, or scheduling, we must be invited, as would happen if it was a court case. Because in a court case, a judge cannot even talk about those practical things with one person without the other one. Then this is not what I'm asking for. But no. So then there's the issue about Mr. Ndo. I can't believe my learned friend, Ms. Power, says that the issue of Ndo was not about relevance at all. That's what she says. Well, that's just not true. The whole point of the objection to Mr. Ndo's alleged sexual harassment being raised or not raised was on the basis that it's not relevant because he didn't make allegations regarding HR issues. I'm just paraphrasing. And we accepted that. That's why in the end, we didn't even question Mr. Ndo on those issues. So it was all about relevance. So to say it was not about relevance at all is not the issue. It was exactly about that. And then to say it was a committee decision, not the chair's decision, just underscores our complaint. That's the point I was making, that when we made relevance issues, they were summarily dismissed by the chair without consulting anybody. But when the evidence leaders made a relevance related issue, it was subjected to a committee process. That's the exact bias I'm talking about, of treating us differently. So I can only say I agree. Evidence leaders have been held to their times, safe, exceptional times. Again, I agree, but that's exactly the point I'm complaining about. It's not that evidence leaders have not been held to the times that were. It's just the evidence leaders have been allowed to choose how much time they need. If they say they want 3 hours, then they get 3 hours. The fact that they get held to the 3 hours doesn't detract from the point from the fact that it is their own self-imposed 3-hour duration. Whereas with us, the duration is then imposed on us, and we're also held to it. So on the holding, yes, it might be equal, but on who determines that's where the bias is. Mr. Stolle, I don't want to get involved in this. Mr. Stolle was cross-examined wrongly and against the prescripts of against the directives in particular. We all know it. The chair might not know it, but Advocate Bauer knows it. She knows exactly what cross-examination is. And Advocate Mayus knows what cross-examination is. I know it. Mr. Stolle knows it. And that's what happened. In fact, Advocate Bauer says herself that Mr. Stolle contradicted himself. And he says he then had an obligation, she then had an obligation to explore. Well, if you are exploring, whatever you call it, a person who has contradicted themselves, that's called cross-examination. And it was wrong. And it's not true either that if there had been no interruptions, that 3 or 4 hour exercise would have taken 1 hour. I can put every little cent I still have, having not been rewarded for my work, that if we played that tape, you'll find that the so-called interruptions did not even come up to half an hour. So, but it's fine. It's a subjective view. It's just false. Yeah. Okay. In terms of reference, yes, thanks to my learned friend. When I mentioned the instruments, Chair, that govern the process, I had forgotten to mention the terms of reference. It is indeed the fifth instrument. And it does say that the evidence leaders should not be prosecutors. Yes. Yeah. I think I've covered all the. Oh, sorry.
Still getting more notes.
Sure.
I'm about to.
I'm sorry, Chair. No. 1 second.
Yeah. Otherwise, those notes will never end.
They won't. Yeah. No, Chair, this is the last one.
There'll be a lot of tweets coming.
And no. Thank God. I'm out of Twitter now since I was insulted there. No, that's a joke. I'm still there, Chair. I just try to hold my peace. No, just one. Yeah, this is from Mr. Sianejo about the fraud. She said that the IT of Sianejo has confirmed that the email was fake. Generally, what happened is that whoever got to know that there was money that was supposed to be paid wrote an email pretending to be coming from Sianejo, saying that the money must be diverted to a particular account, and that was done. And because obviously, I think we can blame the thieves, but also the vigilance of the people who are in the public protector's office, because they should have spotted or called them, but they put the money in the wrong account. Incidentally, another client of Mr. Sianego was also, they tried to dupe them. It's an NGO, not SOE, which I don't need to mention them by name, but they have better systems. So that they called Mr. Sianego, who told them not to pay the amount. And the point I was making there is not, I can't say I've got evidence that the thieves saw the thing here. I'm simply saying that by putting up irrelevant evidence here, that opened Sianego, among others, to that kind of abuse by thieves. If you say to me I must prove it, I'll say I can't. But I'm saying this is the reason why we were saying that irrelevant evidence must not be led, particularly when it involves people's firms or bank accounts and all that. Yeah. Thank you.
Thank you.
Thank you, Chair. Thank you again for your patience, Chair.
On the time now is 15:49, and you would have started just 8 minutes after 3. Just indicating this is what I do all the time.
Well, Chair, you must do it
for
to everyone. No, you don't.
For everybody, including the members. So I'm indicating that sometimes facts matter than any other thing, and I believe in that. So thank you for that, Advocate Mpofu. Maybe just a couple of points to make from the chair. I think the first one will be to acknowledge and welcome the comprehensive application you would have made for the recusal of the chair, as well as Honorable Mailham. That's well received. Members would have asked clarities. As the chair, I don't have clarities. I think we are going to have our own time as a committee to deliberate on the application and definitely make a decision on the application. We're going to give ourselves time to do that, to apply our minds. So I want to thank you for that, and I would have been very patient to give you time to. It's not easy to give somebody 2 hours. In that 2 hours, you are a reference point. Yeah. It's an exercise. It's an exercise. So I would have joked about Honorable Mailham that you were mentioned only in 20 minutes, and yeah, I could just see. It comes with the terrain. For that, thank you. Maybe just also so that a lot of things are clarified from here. I'm going to do this before I make my further points and ask Thembi Nkosi to put that on record and clarify for the purposes of today's meeting. Now, the committee that is the Section 194 is a history-making committee. It's the biggest committee of the National Assembly since 1994. There's never been such a big committee where every party is represented. There's 36 members in this committee, with the ANC having 19 of those, based on the confidence that that organization has from the electorate. Every other committee would have 11 members, and every other committee don't have every party in it. Other parties are not in some committees, but this is one committee where every party is involved. And the quorum of this committee and other committees is not on party line. So for this committee to proceed, you need a certain number. And every time we start our meeting, we don't start it without reaching that quorum. So when we start, we would have conferred, the two of us, that both physically here on, and the quorum is across parties. Well, if a 50% of 36 is 19, based on the strength of proportional representation, sorry, I have to emphasize that point. It what it is, and 6 if it is 11. So as of today, and I'm going to ask him to do that because Honorable Melder might be in Denmark, but the Freedom Front Plus, the alternate was here, Honorable Dana, throughout the day. So I'm going to ask for him to quickly clarify, because after you spoke, Advocate Mpofu, in relation to that ground that related to the three parties you've mentioned under that ground, about 2 emails would have come. One from General Lolo Misa, and you can indicate the time. Can you quickly do that?
Chair, you're exposing Temigosi to a recusal application.
No. Unless you are intending to go there.
Thank you, Chairperson. The email of Honorable Mr. Chair came at 10:43. That was about an hour and 40 minutes after the meeting had started. But safe to say, Chairperson, I've seen the trail of interaction between members where all the members, support staff, and of this committee are copied to. But as the secretary, members are aware of the processes to follow in submitting an apology, and I have not received a formal apology from the 3 members. And just to elaborate, Chairperson, that as you had indicated, some political parties in the committee have full-time members and alternate members, where a full-time member is not present and an alternate member attends, and sometimes they attend both. So, Chair, as much as I have not also received any form of apology from Dr. Melda, Ms. Dana has been on the platform, and she is still on the platform for the FF Plus. Thank you, Chair.
Maybe just to take the point further, I want to recognize the point that was raised by Honorable Heron the day he was sitting there and raising the meeting of today, on the basis that he would be overseas. He would have wished that he be present, and the initial program would have had this week free. And again, I'm going to take you back to Honorable Milam at the very beginning, when we tabled and adopted the terms of reference. He had a problem with what we called a living document, a program that is dynamic, that is going to change all the time. He did not want us to use that language of a living document. So our program is a dynamic one. There are things that are beyond our control, that are forcing us to have meetings sometimes that would not have planned. And I would have explained that to Honorable Heron when he was raising that concern, to say there are things that went beyond our control, that we would have a meeting that we did not plan before. So that would be his concern. But I don't want to labor that point, because if we were to do that, because every meeting we go to where we deal with minutes, because it will open other doors. There are meetings that we go to where parties are just absent, including in this inquiry, and that is reflected in every minute. And so we take note of all of those kind of issues. The second point I want to deal with is I think Honorable Nola has raised this point as a concern. You have attempted to address it, Advocate Mpofu. I'm in agreement with you on that issue, in that I might not have comprehended exactly his concern that he registered. Come again?
I'm not sure if they can hear us on the central platform.
Okay. Okay. Can you hear us, Honorable Mola?
Yes, Chair, I can hear you.
Thank you. Because I'm invoking you, boys. I'm going to talk about you.
No problem, Chair.
Because you have raised a critical point, which is going to be very difficult for us to implement. The one that says about the documentation. And I'm saying I might not have comprehended you very well in terms of the concern you're trying to address. Because what we do, once Tembinkosi sends out documents that the chair would have approved, we lose control of that as to who shares that with who. It gets to be out of our hand. I think Advocate Mpofu was trying to attend to that because remember, we are operating in a transparent. So if we send a document tomorrow for a meeting on Friday, we expect that even the media and everybody else would have had access to that document so that everybody else is ready for that. So it isn't the nature of this. And I'm saying this making the point that I don't know whether that's what you were addressing or you were addressing a different point altogether of a different nature other than what I'm referring to as would be done by Tembinkosi Ngola as the committee secretary. Yeah. Just as a quick comment, I think both yourself, the team of the public protector, the legal team, as well as evidence leaders, you can continue doing what you are doing in terms of the back room. I was never part of the back room. You always met together, and I get the reports of those. Unless you are saying you need my assistance now, I'm available.
No, we'll need the assistance of the new chairperson.
You can't preempt things on Advocate Mpofu. But so you do need the assistance of the chair. Is that what you're saying?
Yes,
no, I will consider that.
Thank you.
And perhaps the next point that I just want to make, Tembinkosi would have sent out a program for a meeting today, as well as a meeting on Friday. And so the ruling that Honorable Zungola would have raised, because Honorable Dlakode made that proposal, this in-committee meeting of ours. And so that has been approved for us. We're going to have to utilize that day, which is Friday, as the committee, because we don't want to delay making a decision on these matters. It can't be prolonged. It will not be fair to the process, to how we want to run and speed up processes in this regard. So we will have that meeting, that committee meeting, that will attend to all of these issues that would have been placed here today. So I'm indicating to members that that will be our next meeting, as was proposed by Honorable Dlakode. And I'm happy that both yourself and Honorable Lothrid addressed the issue of member participation in committees and what becomes a priority at what point. So I don't want to be much longer unless there's something I'm missing. Fatima, anything missing? Okay. Honorable Ngola, you wanted to clarify that issue quickly?
No, sir, I think you captured the point I wanted to make properly. And I think Advocate Mpofu as well did capture it properly in terms of the document that are meant for this committee and them being shared before they are actually tabled in this platform. But another issue that I wanted to just a a plea to all members that we please, all of us as members of this committee, try not to open a different inquiry through social media. Or rather, if it is possible that the whips of the political parties represented can talk about it. Was I remember with the ANC complement, we were told by the Deputy Chief Whip, Honorable Dlakude, that no one is allowed to go and speak about the proceedings of this inquiry into social media, because the problem that we are doing is to
just hold it there, Honorable Mola. You're going to do that on Friday. So
no problem.
Thank you very much, Honorable Siabi.
Thanks, Chair. And my apologies for coming at this stage. Maybe something I must also raise on Friday. As you decide on the meetings, especially those might be beyond our control, as you said, Chair, I think there's a need to consider certain things. For example, okay, wanted your attention. For example, in this committee, there are, in some instances, there will be a chairperson and a whip and other members of a portfolio committee. And if we allow many clashes, yes, there might be a quorum, but it disadvantages those who would not follow the proceedings at the end. I'm just saying, let's look at it. We may discuss it on Friday, or you may look at it at your own time in your office, so that we don't, in the 19 of the ANC, for example, we also include substitutes in that 19. So if the 19 is, or part of the 19 is not there, you're not going to have another person representing there. So let's look at it so that we have, especially with portfolio committees in the mornings, if we can try to avoid, we may not avoid it completely, but if we can try to minimize those clashes. Thank you, Chair.
No, thank you, Honorable Siabe. We'll continue to improve. You will realize that we would have started almost meeting every day. And once other committees came back from recess, we had to readjust in the interest of other committees. But your caution is that even as we change times and dates, we must not lose sight of that, so that we don't lose the consistency of members here because they have got other responsibilities. The homework is taken care of. Thank you for that. Thank you, members, and thank you to everybody, colleagues. The meeting now is adjourned. Thank you.
Recording stopped.
Thank you, Chair. Thank you, Chair.
Good morning, honorable members. Time now is 10
Recording
o'clock.
in progress.
Can I give 1 minute to everybody to start being ready? Just a minute, just to allow everybody to focus and be ready to start our session. Thank you. Yes, honorable members, let me take this opportunity to officially open a meeting of the Portfolio Committee for Public Enterprise on this day of the 21st September 2022, 10 o'clock on Wednesday. And welcome everybody, the Department of Public Enterprises with the team of the SAA, which will be presenting us with the financial statement 2018. I think we're all aware why we'll be receiving that statement today. And also would like to welcome you, honorable members. This is your meeting, and all our guests, including the officials or the staff of our committee that will be helping us in the conduct of this meeting. I will, before I specifically welcome the certain important individuals in this meeting, let me take this opportunity to give to the acting secretary of the committee, Yandisa Tsele. Can you give apologies